addictive potential or abuse potential. That is the word used. So in general idea, it is a first line of treatment. So for list A, you need to have either, it has to be video consultation. That is very specifically they have said. Because list A means list A is given in the first consultation. And invariably in the first consultation, less abuse potential or the first line of treatment. First line of treatment is my interpretation. Here, you will be giving medicine so that they have mandated for a first consultation, video consultation is a must. It cannot be audio, it cannot be email or a text message. Further, this list K can also be given in follow-up consultation. In follow-up consultation, any method can be used for list A. The last, but the list is the list B. List B are those medicines where additional or augmenting medicines are used. So here it can be given in any mode because list B is a follow-up medicine actually. Follow-up medicine means in follow-up consultation in the past 6 months, the doctor had seen him in person. After that, then you are prescribing the medicine, it will be the list B. And finally, one need to understand about this prohibited medicine. Prohibited medicines are those medicines which come under Schedule X of Drugs and Cosmetic Acts and also Narcotic Drugs and Psychotropic Prevention Act of 1985. These are all not should be given. They should not be given on telemedicine because these are all regulated medicine. These medicines can be prescribed only in person. So many of our consultants, psychiatrists, doctors are very unhappy with this section. Again, of course, as a doctors, we have all the right to raise our voice. No, we are unhappy. Let's understand from the perspective of law and order. Suppose Schedule X drugs, which like maybe methylphenidate, it can be morphine, it can be maybe even 4-twin injection, ketamine, whatever it may be, you can call those name drugs, or Corexion's cough syrup. I am sitting in Karnataka where Drugs and Cosmetic Acts has some different rules and I will start writing medicines for the patient sitting in Maharashtra. Now the Maharashtra patient, one patient by name, sorry to say somebody's name, I'll take Professor Ivan Neto's name. He will consult Dr. Suresh from Karnataka. So Karnataka can give OPD basis medicine, drugs and cosmetic medicine. He gives and immediately after 5 minutes, he will contact telemedicine again to Dr. Ravish. He will also give prescription and then again he will contact Dr. Om Prakash. He will also give medicine. These are all controlled medicine. Now Dr. Ivan Nato in the evening goes to a party and he will sell this medicine for, which is in the party pill which will go for 3,000, 4,000, which is available for 5 rupees in the Drugs and Cosmetic Acts, in the, under the medical shop. That means this can be misused. So what is the way out? There is a way out. Here, at this point of time, apart from 2 medicines, that is clonazepam, clobazam, these are the 2 medicines which have been amended and they are allowed in the prohibited list to be given. And another one is phenobarbital. So these are the drugs have been allowed under the prohibited medicines to be prescribed online. Till then, don't prescribe this prohibited medicine. If you prescribe, it is a violation. You may lose your license to practice. So is there a way? Yes, there is a way. The way is, it may be in another 4 or 5 years down the line. Currently, what they are doing is, anyhow, AB, that is basically Ayushman Bharat ID. So every patient will get ID. At the same time, NMC, that is National Medical Commission, is going to tag each doctor with the specific ID. So specific ID is there of the doctor, specific ID of the patient is there. Now, if Dr. Neto being, Evan Neto sir is consulting me, I will prescribe some medicine that will go into the database. And it will be clearly written, Dr. Suresh has given a medicine like this to Dr. So-and-so Neto. And he again contacts Dr. Ravish. Ravish will say, I am seeing there is a medicine given 5 minutes earlier. That means both the doctor who is prescribing is tagged and also the patient will be tagged, which is already occurring in US. So that kind of methodology, it is not far, maybe in another 1 or 2 years, it will be done. Unfortunately, PDP bill, that is basically the protection of private data, which is supposed to be passed, the bill has been withdrawn. If it comes in, these things will become easy, and the whole, the database, what we are looking for across the country, one database for every patient will be an amazing. We will be the leader in the world with regard to public health policy. What is the illness, at what time it comes, what is the, like every year we see in Uttar Pradesh, some illness comes and 200, 300 children are dying. We can get the clear map, when it occurs, where it occurs, what is the type, what are the medicines should be available at that time, what are the doctors should be available. Those mapping can be done easily. So with this, I think I have given rough idea about the medicines, diagnosis and the identification. Over to organizers.
Thank you, sir.
As you all know, Dr. Suresh Badamat and Dr. Ravish are psychiatrists plus advocates or lawyers with a degree in both fields. Now, my question will be to Dr. Ravish now that during telemedicine consultation, what are the various offenses and punishments? And as psychiatrists and mental health professionals here, we would like to know how we can prevent such things from happening.
Sure, sir. Thank you. That's a very valid point for a medical legal specialist. I just want you to recapitulate what my good friend Suresh mentioned in the first round. Now, we are bound by all the laws when we are practicing in person. Along with that, for telemedicine, we are bound by specific laws containing to Information Technology Act 200 and then 2008 amendments. So, first and foremost, this controversy of Scheduled H and Scheduled X, which comes under Drug and Cosmetic Act 1940 and then Drug and Cosmetic Rule 1945. Also, NFPS Act, I think with regard to Scheduled X drug, the previous panelist, Dr. Suresh, has mentioned comprehensively. Now, if you prescribe, definitely, I don't want to scare you with all the punishments. See, punishment can vary between 3 months to 2 years of imprisonment and then fine between 5,000 to 2 lakhs. It varies. But what is important? Offenses can happen in 2 ways. One is civil and the second one is criminal. In the medical jurisprudence, the main issue will be medical negligence and medical misconduct. See, when we come to medical negligence, so we have this IT Act. Within IT Act, there are again, I'm not talking about the economical offenses, I'm relating only to the personal privacy or the damage with relation to personal information. So section 43A to H is concerned about the civil offences. Section 63 to 74 is concerned with criminal offences. Now it becomes civil and criminal mainly with if there is a damage. Okay, we always learned this during our forensic medicine training. The 4 Ds, there should be direct connection, there should be duty, third, there should be diligence, and then fourth, death. Now, with regard to further information technology about the privacy issue, because around the globe, people are more scared to have these kind of sharing of information, mainly with regard to where this breach of privacy will happen. I would just read one rule. It's quite big, that's why. The information technology reasonable security practices and procedures and sensitive personal data or information rules 2011. Why I am quoting this is in the case of retired Justice Putsami versus Union of India, the 5-bench committee court decides that right to privacy is a fundamental right. So why I am telling is it becomes a fundamental violation if the data protection is not done. Yes, PDP, Personal Data Protection Bill, it started in 2018, ultimately it was dropped in 2022, mainly because it needs some amount of amendment and correction and more watertight compartments. So probably, as Suresh was mentioning, we will receive much better version of it. Now, see, the doctor-patient relationship, in person, definitely that kind of a relationship starts, but people have now been speaking about telemedical jurisprudence, because there is no such kind of relationship that develops as same as that between in-person relationship, but all the other aspects, that's a little bit of controversial part. So all the other aspects do exist. So you have to follow the Indian Medical Council's guidelines and the rules, okay? And if you break such things, definitely the Medical Council, which is now NMC has recently given a direction to all the state medical councils for any disciplinary actions to be taken at the state level itself. Now coming to what are the criminal negligences? Again, Indian Penal Code, the famous IPC 304A, when the death happens, of course, the death is not usually intentional, but still, okay, it will be registered under IPC 304A. Then, if there is a hurt, okay, if there is a hurt that has been caused, it is IPC 336. If that hurt is of grievous nature, how does that come? Okay, as Dr. Suresh was mentioning, the litigation level is not so complicated as that of in-person consultation. If at all, if it comes, as I was highly emphasizing, it was related to privacy, confidentiality maintenance. The second thing is prescribing the drugs, okay, which can be detrimental. Vicarious liability, that is another thing. Now, vicarious liability, because there are third parties who are involving between patient and doctor, providing the platform. So that part will be a vicarious liability on the person, the third party which is giving this via media performance. Also, will be governed by Consumer Protection Act of 1986. Let us not forget it. And as psychiatrists, Mental Health Care Act will always be with us. Okay. Now, the important aspect is how to prevent. Okay. See, first and foremost, you need to be transparent. Okay. Transparent meaning between the patient and the doctor. As it was discussed about the identification. Okay. And then confirmation of the protection of the confidentiality and privacy. Then consent. So here people can't say that I didn't consent, because the moment they came to the consultation, that's why most of the litigations will come down. Second thing is, medical errors do happen, but if the communication is good, so that will not go into the extent of litigation. Now, whenever you are in doubt, so this utilize the autonomy which was spoken. You tell them that I want to see you in person. Whenever there is any amount of doubt, and when you can't come to a provisional diagnosis, and this is a right, this is a discretionary right given to the doctor as well as to the patient. So both can exercise this. This will prevent a lot of litigations. And whenever in doubt, please take second opinion. do not put your egos in front of it. Okay, there is always a safety when you either ask them or you yourself can take the second opinion. Documentation, everything that you have done, please document it. Without documentation, as you all know, nothing has been done. And please keep updated. Okay, you can't ignore the land of the law of the land. Okay, you can't be negligent and say, okay, we didn't know about these amendments. Please understand, as psychiatrists, we are being taught to empathize, but do not take all the responsibilities on your head. You can't fulfill all the expectations of the client, because we keep telling every patient who walks into your consultation room is a potential litigant. So you need to stick on to the guidelines. Don't be adventurous. This is my honest suggestions to my colleagues and all my professionals. Thank you. Over to the organizer.
Thank you, Dr. Ramesh, for your advice and your guidance.
No. My question is to Madam Dipti Lele. Actually, it's again a lengthy question. I will make it into two. The first part is, Madam, kindly advise regarding cyber safety for children and various mental health professionals. This is part one. I think you will answer this first. Advise us regarding cyber safety for children and various mental health professionals.
Okay. Thank you, sir, doctor. Basically, cyber parenting is a new concept which has emerged. So cyber safety for kids is really important. If you will go in any of the functions, so please observe that kids are not playing with each other. They are playing on internet. They are connected with each other on internet, though they are in the same hall. So this is a really big problem for all of us, psychiatrists, psychologists, and for lawyers also. So we need to take care. As a parent also, there is a big responsibility on our shoulders. So regarding children, basically, I just wanted to tell you, embrace the technology. So you can't say that I don't know, I don't have account on Facebook, I don't access social media, but if you are a parent of your kid, and kids are aware about all these things. So if you want to control them in virtual world, basically you have to learn the technology first. Second, educate your kids about what is good, what is bad, ethics, then digital communication, digital membership, everything. So new education policy, they have introduced all these things. They have included everything. After that, cyber hygiene is a big problem, or safety. So it goes hand in hand. So you can know your kid, basically, know your kid. Then kids should be aware if they are playing the games. So what are the settings which are available? Second, if you are a parent, please learn to say no to your kids. Say no to your kids. Third, there should be restrict your screen time and the rules should be for the whole family. Next, teach your kids about different code of conducts which are available for all the gaming zones. So normally kids play the games. They should be aware about it. Then they should be aware about how to check the authenticity or legacy of any website which they are accessing for anything. They should be aware how to, if anything will happen, then they need to talk to the parents first, or the person they trust most. Okay. So again, I think sir said about transparency. So it is also applicable over here. Then they need to understand that if anything will happen, you can sit at home, you can file a case in cybercrime.gov.in. how to check the legacy, you have to go to domaintools.com. So this is a website where you can just copy all the URL and you can paste. Then many things are there actually. Open communication should be there with your kids. This is for the kids basically, and for the professionals. Basically, IPR infringement is increasing on a very large basis, especially for doctors. Then, as sir said, ransomware attacks are increasing at professional levels. Hacking of your hospital's data. Again, you need to understand three things. I think Ravin sir mentioned about reasonable security practices. It should be followed for everywhere, for every institution. Reasonable security practices, know about sensitive personal data and personal data, again, which is important because hospital is also working as intermediary. Am I right, sir? Hospitals are also intermediaries. So again, there is a big responsibility on your shoulder when you are working as an intermediary because you are liable for that. So be careful. Then many safety measures you have to take when you are doing monetary transactions. So I think I will take 1 hour. So list will go on. I hope it is clear for you. Thank you.
Yeah. The next part of the question, madam, is what are women and children related cyber abuse and how can they be prevented? Women and children related cyber abuse and how can they be prevented? That's the last part.
Okay. So, especially for women and small girls, during the pandemic, I have gone through many cases of cyber grooming. Maybe this is a new concept for all of us. Cyber grooming was increased on a very large basis. 15 kids, I talked to them. I did technical counseling. Technical counseling is not a counseling to show them if you will do this, then what will happen. You should not do that. So cyber grooming is going on. Cyber grooming means your kid will start talking to some stranger and he will try to gain his trust, and the moment will come your kid will not trust you. Your kid will listen to the stranger and he will do as the stranger is talking. So I already told you the difference. The person to whom you are talking in the cyber world may not be the same person. So cyber grooming is a big problem. Then cyber stalking, as sir mentions. Cyber stalking, bullying. In kids' case, it is called bullying. It is the same. Stalking is for elders and bullying is for small kids. So bullying, now the kids are also started bullying. If you will see, check the concept of bullying in physical world. So if you remember groupism, we do groupism. We don't talk to one person. मराठीत म्हणतो ना कोपऱ्यात घेतो आपण. Then we just don't include the person in WhatsApp group. So stalking is going on in physical world also. But when online classes were going on, cyber stalking was increasing among the kids also. And the students, the classmates only they were doing the cyber stalking, or you can say bullying. Especially for the girls, bullying is increasing. So fake news, then spreading rumors against the girl or to harass the girl. So it comes under cyber, blackmailing the girl, it comes under that. But you need to teach the girl or the daughter that if anything will happen, immediately contact the parents or any trustworthy person. Now, if you remember, when we were having the telephones, we were not having the mobiles. So we used to stick a list over there, important numbers of our relatives. Now the time has come, you have to stick the numbers of cyber crime police station, then your bank managers, then cyber security experts, cyber lawyers. It is really important. So it should be handy with you. Thank you.
A gentle reminder that we started late, so we have gone a little bit more than the time. So we'll have one question to the panelists, and after that, just 2 questions from the audience. Okay?
This is the last of the questions to Sri Pawar. What is the punishment for the various cyber crimes? And enlighten us regarding the current cyber world in India.
Thank you, sir. All cyber crimes, what I have explained before, cognizable. All are cognizable. They are charge sheeted in the court of law. The hacking, ransomware, data theft, this all under Information Technology Act 4366. The punishment is for 3 years, up to 3 years imprisonment and 1 lakh rupees fine. Then for identity theft 66C, it's also imprisonment for 3 years and 1 lakh rupees. For cheating with personation 66D, it's also up to 3 years imprisonment and 1 lakh rupees. The IPC also 419 and 420, these also applicable for this data theft, identity theft. Then cyber stalking, it also comes under IT Act 67 and in also IPC 354D. For under 354D, it is imprisonment up to 5 years. And under Cyber Act 67, it is imprisonment up to 3 years. Then violation of the privacy 66E, the imprisonment up to 5 years and 5 lakh rupees fine. Then 67A, this is a punishment also up to 5 years imprisonment. Then child pornography. In India, child pornography is a crime. It comes under 67B and punishment up to 5 years. Even if we see child pornography in house, that is also crime. And punishment is up to 5 years and 5 lakh rupees. And cyber terrorism 66F, the punishment is up to 10 years and 5 lakh rupees fine. These all are punishments under cyber crime and cyber law in IPC. The next question is today's cyber world. In Pune city, last crime rate was regular crime, that is body offenses up to murder, property offenses, vehicle theft, to four-wheeler theft, purse chori and all this. The crime was 10,000 in last year and cyber crime was 25,000, 2.5 times more. In regular crime, the property stolen was 10 crore. In cyber crime, it was 100 crores. This is the big difference and more challenges in this. And this scenario is to Pune, to all Maharashtra, to all India. It's in literature that every American, 72% of the Americans, one or more time is cheated or fell for the cyber crime. We all from here also one time or cheated for the cyber crimes. And in India, that is lack of awareness is the main reason to increase the cyber crime. Nowadays, I have already told that the main 2-3 cyber crimes are in Pune city. That is loan fraud. You have read in paper that 400 loan apps are destroyed by the Indian government that was created from China. 400. Even if you don't want the loan, the fraudsters put loan money in your account and then harass you to refund that money. This is challenging cyber crime nowadays. Then MSCB bill I have mentioned. Then third crime nowadays in much more is sextortion or video calling. These 3 crimes are up to 60%. In all, the economic crimes are 80% of all total cyber crimes, and then social media crime is only 20%. That the cyber crime is done for the money, and that is 80% of the cyber crimes. You don't know 42% of the economic Nigeria is from Indians money of the cyber crime. All Nigerians are at Mumbai, at Delhi. They come on student visa and do here cyber crime. In Jamtara, you have seen in the story serial in Jamtara, we got gone there to take culprit. All their totally villages doing the same crime. No any employment there, only doing cyber crime. One laptop, 10, 20 mobiles in hand, and single man doing all cyber crime, cheating, fooling out to all Indian. In the Rajasthan, in Bharatpur area, these sextortion cases are there. In Delhi area, Noida area, all 200, 300, all classes are there, and they are all doing cyber crimes. This is the overall scenario in India and Maharashtra. Thank you, sir.
Thank you, sir, for a very elaborative answer. It's now the turn of audience. We'll take one question. Yeah, please. Mike, please.
Thank you. Good afternoon to everybody. My question was to Badamat sir. Nowadays, many insurance companies are asking for indoor case papers. In a hospital setup, are we expected to give indoor case papers to the insurance companies? As of practice now, we don't take any explicit consent from the patient at the time of admission. Do we need to take the consent and then give the papers to the insurance company? We don't have any idea about the settlement because very few claims are getting settled if the insurance is provided by the employer's company or the patient or claimant's employing company. But so I wanted to ask these questions. Thank you.
Thank you very much, Ma. It's an excellent question. This has been not only the problem in India, but also in Australia. The health minister had to come on the parliament to answer this question. Okay, I have got the privilege to answer such question. Okay, here it is like this. When the patients, when a party signs with the insurance company, it is a contract between the patient party and the insurance company. Now the patient party has come for treatment here. So under IRDA, they have entitled to take the records. That means the insurance company, because the patient has given the authority, or what we call it as authorized signatory, so that the insurance company can take. That is the way it has been there. But however, for psychiatrists, there is a Mental Health Care Act comes into picture. Mental Health Care Act of 2017. Section 25 clearly says, right to basic medical record is only for the patient, not even for the family members. So in such a scenario, what to be done? I would put it simply like this. The mental health records, one is physical health record, they are also sensitive, but mental health records becomes very sensitive because of stigma or discrimination. For that reason, you have to follow Mental Health Care Act of 2017. You will say very clearly, if the patient is going to claim insurance, you have to talk to him and say, these are the data available. You are entitled for basic medical record. I can give you the basic medical record. You can submit to the insurance company. Or else, if the patient says, I want the whole file again, that has to be released by the Mental Health Review Board as per the Mental Health Care Act of 2017. But however, if you feel that it is justified, you can give the complete file also. But you will be giving to the patient, like the patient submit to the insurance company. That is the best way to deal. Because many a time the patient could have given a lot of sensitive information about the family, about his mental illness, about his various delusions and hallucination. I would rather refrain sharing all those records with the insurance company. And again, it is both in public and also private, especially in Australia. One of the example I can give you is, there the government was asking the complete records. There was a question asked by the human rights activist, why you want the whole record? Here you want to know whether the records were the treatment part only. Diagnosis, why you want the whole record? Finally, it has been ratified there, clearly telling that the minimum requirement for the purpose of insurance has to be given. That is in the Australia. It is not far even in India. because even if you take Ayushman Bharat, they are taking the whole file actually when the government has to give. That is unwanted, unwarranted. It is a waste of money, waste of resources doing all the things. But anyhow, but somebody has to come and say, no, don't do this. Invariable in India, it is Supreme Court. Till then, it will continue. So for your question, the answer is very simple. Give the records to the patient, let the patient submit to the insurance company, or else you take the authorization signature that you have been authorized to, the insurance company has authorized to give the records to the, that the patient has authorized to you. So that you can do it and safeguard yourself under the Mental Health Care Act of 2017. Hope I answered your question.
I think this can go on for any length of time. It was just such an interesting and new topic, cybercrime and anything related to that. I'm really grateful to the organizing committee of this CME today, and Professor Netto in particular, for allowing all three of us, and Brigadier Raju, myself, and Dr. Deshpande, on behalf of three of us, I thank you very much, the organizing committee. And I'm extremely thankful to all the three panelists who are online, Badamat, Ravish and O.P. Singh Sahab, and those who are present in person, Deepti ji and ACP Pawar Sahib. Thank you very much. It was an enlightening experience for me. It was totally new learning. I never knew the world called doxing, or never knew the world called stalking. I was knowing, but doxing was completely new. Thank you very much. And on behalf of all of us, I thank all the audience for keeping the interest alive. Thank you very much.
I thank all our panelists for bringing such nuance to our understanding of this new and evolving subject. Now let us proceed with the felicitation of our panelists. I would like to mention here that the artwork on the bags being presented has been done by the patients attending the OPD at the Department of Psychiatry, BJMC, and Maharashtra Institute of Mental Health, Pune. I now request Dr. Ivan Netto sir to felicitate our online panelists, Dr. Om Prakash Singh, Dr. Ravish PN, and Dr. Suresh Badamat.
Sir, accept these invitations these mementos from all of us, Dr. Suresh, Dr. Ravish, Dr. O.P. Singh, and it will be sent to you by courier with a certificate.
Thank you, sir. Your blessings are always important.
Keeping in line the NMC rules. Okay? Thank you, sir.
Thanks.
I now request Dr. Vidyadhar Vatve to felicitate Shri Sunil Pawar. I now request Dr. MSVK Raju to felicitate Dr. Deepti Lele ma'am.
Next, I request Dr. Madhumita Bahale to felicitate Dr. Vidyadhar Vatve sir. I request Dr. Manjeet Santre to felicitate Dr. MSVK Raju. request Dr. Smita Panse to felicitate Dr. Prasad Deshpande. I request Dr. Dharmendra Kendre to felicitate Dr. Ivan Netto. Thank you, sir. I once again thank all our respected speakers. This brings us to the end of our panel discussion. I request everyone to kindly gather in the dining area for tea and snacks. The next panel discussion will be starting by 4:15 p.m. I request everyone to be on time for that. Thank you. Panel for today, which is on the Protection of Children from Sexual Offences Act 2012. First, I'd like to call upon stage our moderators for this panel. I welcome Surgeon Commodore Kaushik Chatterjee. He is the Professor and Head of Department of Psychiatry at Armed Forces Medical College, Pune. Starting with our fourth panel, we are joined here on stage, Surgeon Commodore Kaushik Chatterjee, Professor and Head of Department of Psychiatry, Armed Forces Medical College, Pune. We welcome you, sir. Next, I'd like to call upon stage Dr. Smita Panse, Associate Professor at PCMC's Postgraduate Institute and Yashwantrao Chavan Memorial Hospital, Pune. I'd like to call upon stage Dr. Ivan Netto, Chairperson, Forensic Psychiatry and Law Specialty Section of the Indian Psychiatric Society.
Next, I would like to call upon stage our panelists. I welcome Dr. Jyoti Shetty, Professor and Head of Department of Psychiatry, Bharati Vidyapeeth University, Pune. Also, she is the advisor for POCSO and JJ Act Task Force of the Indian Psychiatric Society. I welcome Dr. Suchita Agrawal. She is a psychiatrist and consultant researcher for the Program for Primary Prevention of Sexual Violence at KEM Hospital, Pune. Next, I welcome on stage Dr. Yajoti Singh, who is equipped with a Master's in Developmental Psychology and also an advisory committee member of Muskan, which is an NGO working against child sexual abuse. I welcome Advocate Rama Sarote, lawyer and trainer in women and child rights. I would now like to hand over the mic to Dr. Ivan Netto, sir, for explaining the ground rules for this panel discussion.
I have to repeat the ground rules because some are new to the sessions here. The ground rules are for the smooth functioning of the panel so that moderators, panelists, and the audience can effectively take part in the panel discussion. We have 4 panelists in person and one panelist, Dr. Bhushan Shukla, the child psychiatrist. He was unable to connect, hijacked, if you may say, but we thought he was hijacked, but then finally he sent in a audio clip, and his questions which were asked to him on the cyber or the virtual world will be replayed while he's asked the question. The moderators will ask one question to each panelist. The panelist will answer the question within 4 minutes. There will be 2 rounds of questions. If the panelist exceeds 4 minutes, a bell will be rung. After that, the moderators will welcome questions from the audience. Please bear with us. This panel has begun half an hour late. So it was supposed to start at 4 o'clock, but now it's starting at 4:30 almost. So it's going to end at 5:30. Thank you. So I now hand over to the moderators.
As we all know, POCSO is an idea which the time of which has come, or rather overdue. And because it is being implemented in fits and starts, there are lacunae, and many psychiatrists have had to deal with situations where they found it difficult to grapple with. So I shall go first to Dr. Jyoti Shetty, who knows all about POCSO. Why is that? Because she was the advisor to the POCSO task force of IPS. So please give us a brief overview of the Act and your role as advisor.
Thank you. Thank you, Dr. Kaushik. I thank the Department of Psychiatry, BJ Medical College, MIMH Pune, and the Forensic Psychiatry Subspecialties team of the IPS for inviting me here today, and the moderators here. Thank you, all the delegates who have waited so long. So coming to what is POCSO, I think as it was already announced, Protection of Children from Sexual Offences Act 2012 came about following a survey of child sexual abuse, the report of which was presented by the MP of that time, Mrs. Renuka Chaudhary, which was in 2007. And about 12,447 children were interviewed. And surprisingly, the statistics were very disheartening. It was found that 52% of the children who were abused were boys. Rest, there was so much of abuse that it was necessary that this act be formulated. So that's why it has come into being. It has been in effect since 14th of November 2012, and it is gender neutral. I mean, I think one of the biggest highlights of the act is that it is gender neutral. It covers all forms of child sexual abuse, including not only penetrative abuse, but also molestation, harassment. It also covers pornography, where children and adolescents or minors are used. It also lays down certain rules and regulations in terms of not only about the quantum of punishment for these offenses. There are different chapters which are dedicated to elaborating on the offenses, of course, but it also lays down how
the investigating officers need to investigate and interview the children. It also lays down standards for health professionals for examining and interviewing the children in case of child sexual abuse. Another highlight of this act is the mandatory reporting, which actually has been a bugbear, because I think there will be more discussion on that later also. Because that is something that when the act came out, that was something that was extremely, I think as clinicians who see children every day, it was almost, prohibitive as to, like, do we take a history when something like this is reported to us? What are we supposed to do? So that mandatory reporting clause is something that has brought in. Of course, it's to protect the children. It's also to protect the families. But the whole point of the punishment and the punishment if you do not report is, I think, something that I think as clinicians we have been a little bit averse to. But of course, I think even the IPS, in fact, we have clinical practice guidelines which has been brought out in 2019, which was written by Dr. Shekhar Sheshadri and his team on how to assess and intervene in a case of child sexual abuse. So then, there are lots of areas that we can go into. So that is, I think if there is anything more, we can always come back to the discussion. Yeah. Thank you.
My question is to Advocate Rama Sarode. We have heard her in the morning and seen the expertise regarding marriage and mental illness. So coming to POCSO, as per National Crimes Records Bureau report, the rate of conviction in CSA under POCSO Act is just 35%, and almost 90% cases are still pending. So as there is low reporting of crime, what can be the reason behind this and how can it be remedied?
Good evening. Yes, and that's true of most cases related to children as well as women, crimes against women, mostly sexual offense, I would say, where the conviction rate is very low and there is a lot of pendency and non-reporting as well. As far as POCSO goes and as far as children go, we have to understand that children are even more vulnerable because they cannot go and report on their own. So they are depending on somebody else to go and report. Now, even before somebody else goes and reports, they need to disclose what has happened to them. Do they have an open discussion with parents? Can they have an open discussion with teachers? Can they have an open discussion with relatives? Are they going to be judged because of that? These are a lot of questions, that they face. Also, are they aware of what is sexual offense and how do you identify it and whom do you go and speak to? Most of them I have worked with schools, I have worked with Muskan, and most parents, unfortunately, don't believe their own kids. And that's very unfortunate. And most of the time, the Crime in India report of 2019 says that 98.98% cases of POCSO in Maharashtra are from people who are known to them and mostly relatives. So the moment it is somebody known, they would trust an adult as compared to a child. And of course, there are a lot of gray areas in this law as well. For example, two minor, who are in love with each other, and the parents would want a offense to be registered against one. And both of them actually have the protection of this law. But nonetheless, when I've trained police and when I ask them, okay, so whom are you going to file the complaint against, or who's going to be the accused here? And they inadvertently say it's the boy. And why is that so? Because he also needs protection under this law. But that's a kind of sensitivity that is not there. And nowadays it's become a trend that if parents don't want to report, if school doesn't want to report, if people who know about the offense do not want to report, the police are not registering cases in spite of knowing that it's such a serious offense. So I'm not surprised that the reporting is low and the conviction rate is also low.
Now the question is for Dr. Bhushan Shukla. Now he is unable to connect, but when I spoke to him, he gave me the answer on an audio clip, so which will be replayed. I asked him, what do we understand by child-friendly procedures for medical examination in the POCSO Act? What are the challenges faced in teaching good touch and bad touch to children in schools? If you go to the YouTube channel, you will see there is a YouTube video by Dr. Bhushan Shukla, who has done something on good touch, bad touch with children. So, Dr. Som, would you play the audio clip?
Good afternoon, everybody. I'm sorry that I'm unable to be there in person. I'm traveling just now and in a poor connectivity area, so sending an audio clip for all of you. The question that I'm asked is about the most child-friendly procedure to interview the child and record the interview. One thing I have realized over last 7 or 8 years of POCSO is that children get traumatized more by repetitive questioning by different agencies than anything else. And their confidentiality and privacy is a big issue for their families. So any procedure that requires the child to tell their story only once and not repetitively again turns out to be the best and most child-friendly procedure. If possible, the interviewing psychiatrist or psychologist should be sitting there with the child, and maybe the police person can also be present to record that, particularly the investigating officer. And open-ended narrative type of questioning helps the children open up much better and describe everything in detail. Second part of the question is about my experience with good touch, bad touch workshops. The most important thing to remember is that the good touch, bad touch, this nice sounding words that are put together is a journalistic nonsense. In real life, anybody who has ever worked with children who are abused knows that more than 95% of the children are abused by people who are very close to them, who are part of the family. And these people spend significant amount of time, months sometimes, grooming the child before they actually conduct a sexual assault of any form. Now this grooming part invariably involves what is conventionally told to the child as good touch. And this is a big problem. That is why when people insist on talking about good touch in this workshop, they are essentially damaging the very core of this safety training. This safety training is about helping children identify what is bad touch. So there should be no discussion about good touch in this workshop. That actually harms children in long run. All that they need to be told is which part of their body are and should be inaccessible to other people, and if anybody touches them in that part, what are they supposed to do? That is all it is about. Now when I started doing this workshop almost 22 years ago, first workshop was done in 2000, there was obviously a lot of hostility from all the schools and children's agencies. I have been driven out of the schools quite a few times, but ultimately POCSO happened, Satyameva Jayate happened, and all of this suddenly got a lot of acceptance from schools. So now it is a lot more easy to talk to parents and schools and train this to children. But I must insist once again, insistence on getting this good touch, bad touch together is nonsense. This is unscientific. This is outright harmful for the children. We should only be talking about bad touch and nothing more.
My question next is to Dr. Sucheta Agarwal. Pedophilia is now being described as a neurodevelopmental disorder. Is it, in your opinion, a way to protect some? Does it change our perspective regarding the way we see pedophilia and in the prevention of child sexual abuse?
Thank you so much for that question.
So yes, pedophilia is just like any other psychiatric disorder with a biopsychosocial origin. So not just neurodevelopmental, but also involves all the other aspects as well. So when we talk of biology, yes, definitely neurodevelopmental, genetic, neuroendocrine factors are there, and neuroanatomical factors are there. So some research has been done. There are results. Some are consistent, some are inconsistent. So again, not to dismiss them, just like in all other psychiatric disorders, we don't get very consistent results when it comes to biology. But yes, and also second is then comes psychological factors. So when we talk about psychological factors, again, learning theories come into play. Think when I'm talking about pedophilia, try and think about homosexuality or bisexuality and things like that. So very similar etiologies come into play where learning theories are there. If there is a history of abuse, childhood sexual abuse, then that can also be one of the factors. Not everybody who has has been abused in childhood will become go on to develop pedophilic disorder. Also, some social factors can play a role where the social environment is not appropriate for the person. There are socio-affective deficits in the environment which is leading to development of some kind of personality disorders. So those everything together gives rise to pedophilia. Now, when you say that, yes, pedophilia, should it be changing the perspective, or how can it change, how can we work with prevention? So when you're talking about that, I hope that knowing this information, many of you will be okay, will at least consider treatment of such patients. If many of us are not equipped, many of us don't know what to do when such a person reveals that they have a sexual attraction towards children. Now again, very important point would be that pedophilia is not child sexual abuse. Pedophilia is simply a sexual orientation, a sexual attraction, or a sexual urge, as you can call it. But it does not amount to child sexual abuse unless it is acted upon. So this is very, very important to remember. If we open DSM-5, many of us don't go to that section and read, but if we have seen, then it just means that recurrent intense sexual urges which are directed towards prepubescent children. That is what pedophilia is. And even when we talk about pedophilic disorder, it just means that there is presence of distress, there is presence of interpersonal difficulty in addition to these urges. Third point is, yes, if somebody has acted on it, again they will fall under pedophilic disorder. So this is something that is again debatable. Why are we saying and why are we considering an offense in the DSM-5? I don't know any other offense which is put in DSM-5 as a disorder, right? So that creates confusion again. So for our sakes, it should be something that we say, okay, this is pedophilic disorder. If these urges have lasted for more than 6 months, if there is consistency, if there is recurrence, if the person has identified it, it's more of subjective again. So again, taking example of homosexuality, the person knows, you cannot decide for them. The person knows what they are attracted to, who they are attracted to. So I hope it helps change the perspective, definitely. Thank you.
Okay, so coming back to child sexual abuse, I would like to ask Mrs. Yajoti Singh, in her experience, what are the challenges faced during disclosure by the child regarding the CSA, and how do we handle them?
Thank you, Dr. Pansay, for the question. A very good evening, and I'm humbled to be here amidst all of you all. Disclosure, am I audible? Since disclosure is one of the most important parts in this entire process, ideally we imagine it in a clinical setting with the clinician in a very safe environment, and that, yes, does give the maximum output. But 75% of the time it does not happen like that. So very often it depends on where and how the disclosure is needed. And when talking about an NGO, so when I'm talking about Muskan, the kind of cases that come to us sometimes come directly from the police. It's an SOS case, probably a 4.5-year-old girl who has evidential proof of penetration, and she's not talking. And this is where they kind of rope us in to help with disclosure. 4.5-year-old, she has speech problems. She is in shock. There's post-trauma, complete shock that she's gone into, and there's pressure from the parent because she was a missing child and she's been found on the terrace in this state. So disclosure at this point is something which actually could go on for an entire 15 to 20 days to a month. Then there are incidental disclosures which happen with parents at home, and we get this kind of a thing that I think we suspected. For example, a 2.5-year-old who in the course of conversation, while she was being offered jelly sweets, suddenly said, "So now what do I have to do?" So then the mother got a little suspicious and she started probing, and she said, "I have managed to get a little bit." So then we get partial disclosures, which could be contaminated because here very often the person to whom the disclosure is being made could have their own biases, could then be completing sentences for the child, could be having shock value, and could be clamming up the child completely. So very, very pertinent is to get the complete disclosure, which never really happens because these partial disclosures sometimes have to be undone and redone. So getting the narrative for us is the biggest challenge, getting the authentic narrative which is there. So there are cases where children could be having special needs. So an autistic child who obviously she was not cognizant of the fact that there was any kind of sexual abuse. And then to get her to disclose can again be a challenge. So very often we need to bring in the parents, bring in the one parent who is extremely close to the child, inform the parent. So along with disclosure, there's a lot of parallel psychoeducation which is going on in order to prepare the parent for what to expect and how to go about this. To a large extent, parents midway through the process of disclosure, which could be 1, 2, 3rd session, they completely retract and they just want to back off completely. So here it also could be related to the age of the child, the IQ level of the child, the availability of the expressive skills of the child in terms of how the disclosure is done. So for example, so we bring in a lot of expressive therapies here, but even with the expressive therapies, to have that same play therapy enacted again, to bring in the consistency in bringing out a narrative becomes very important because the same thing is going to be asked to the child in court again. Preparing the child that this is not the last time disclosure is going to happen. So the trauma gets repeated. Teenagers want confidentiality. And the minute they come and confide with that huge space of safety, and then we tell the parents, we tell somebody else, they have to lodge an FIR, the police are, that shattering is dual. And at that point, it becomes extremely difficult for them. So this whole process of disclosure, also what happens is, though the POCSO law says that the FIR with the child doesn't need proof, it has to be done in a private setting, not in the police station, plain clothes, all that is there. But very often the parents get the child along during the first time. The FIR is lodged with the child there, and the way the questioning is done, it sounds very confrontational. So it's like, so you saw it, did you do that? Was it done? And the child is like, am I? That sense of criminality bounces right back. As it is, it all depends on whether it was aggravated sexual assault. Because if it's a family member, then getting any kind of support from the entire family sometimes is bleak. And then the children completely retract. Sometimes it's the mother who wants to push it under the carpet. If there are disclosures which happen after a POCSO training session, which happens very often, the next day the child has completely retracted, saying, no, it was just, I think it was my friend's thing I was talking about, because obviously the parents have told them not to do it. So disclosure is still a huge challenge because it's like from the cup to the lip. The child wants to disclose, they've understood what it is, but support from the parents, their kind of reactions that they give, the amount of support. Sometimes we've seen that it's the lower strata who are reporting more because they're coming to us more, but the middle and the upper strata completely push it below the carpet. So it's still a challenge.
This question is for Dr. Jyoti Shetty. Jyoti, I remember you telling me some time ago about some of your POCSO cases. Normally, especially if there is a girl child, then a male doctor is not supposed to be there. So could you tell us, as a psychiatrist or as a mental health professional, how do we and what role do we play in the case of CSA?
Thank you, Dr. Netto. At the outset, I would like to say that all of us, I think health professionals at one's level, are equally responsible in actually knowing the laid down guidelines to address a case of child sexual abuse. Here I would also like to add at the outset that helps. I mean, this is for everyone out here, whether it's at an institute level, whether it's even if you're practicing in a clinic, it's good to have some SOPs based on, how the POCSO works. So, for example, just to elaborate, like at Bharti, we have SOP for all cases of child sexual abuse, because such cases, whether reported, whether it comes out during the course of some sort of examination, whether it comes, the child has been brought for something and then, it's something that comes out incidentally in some history. It could be even brought out to a paramedical staff, for example. So it always helps to have an SOP in place as to how to go forward. So what we usually have is that at the outset, all the interviews, the laid down guidelines are to basically protect the child's or the minor's rights. So it's a minor's right to safety, the minor's right to have confidentiality and privacy, the minor's right to be able to disclose, to be educated that what happens with the disclosure, and also to be, the process is pretty long. As Dr. Jyoti was saying that, it's the disclosure is at several levels and several times over time. And irrespective of what POCSO lays down, that, the case has to be wound up within 1 year, I think unfortunately our legal system works very slowly. So that doesn't happen. So there's repeated re-victimization that happens. So for this reason, it is important to educate the child or the minor and the family that, this is something that can come up. So at the outset, it is also important to also, see that they are safe and protected. It often happens that, it could be a psychologist. We had one case where, it was a psychologist. In the course of assessment and counseling, the child reported. So there should be some sort of escalation SOP where, a psychiatrist or a mental health professional, a senior mental health professional is brought into the picture. There is more interviewing. It is also required that, when we are talking about the roles of psychiatrists, it's not only about our role as clinicians in terms of taking care of the trauma that the child or the minor is dealing with. It's also about intervention. We are also called as fact and expert witnesses in court. So it is also about our documentation of what has happened that needs to be taken into account. So the documentation in terms of what you're writing, what you have elicited, how you have elicited, what you have done with the examination, for example, which is why I mentioned even the article, the CPG that I was mentioning, is something that is important for all of us to read through, is because it actually lays down what has to be done. So how the questioning could be done, probably initially open-ended, then closing up. It's also about creating a therapeutic rapport with the child during the process of interviewing and disclosure, because it could be that, the child may or may not come back, may be, dealt by other health professionals or by the system. But at least when you create some sort of therapeutic alliance, there is a hope that the child, could come back for any sort of help, mental health issues that come up later. So it is important for that reason that we as psychiatrists, initially when we are interviewing, that, we take the child to a safe space. We see that we are in a room, depending on the age of the individual, age of the child, very small children probably may not be able to verbalize or vocalize what has happened to them. So you could use probably, dolls or, some sort of play or drawings, depending on the age of the child again. I mean, if it is adolescence, unfortunately what happens is it could be the abuses in the context of some relationship that has happened during the, what we say is the grooming process. So that needs to be clarified. So the assessment may vary depending on the age. And it is important to build a therapeutic alliance as mental health professionals, because as I said, it's not only for the intervention at that point, but it's also for addressing the trauma and the trauma-related mental health issues that may come up later. Thank you.
My question is to Advocate Rama Sarode. Ma'am, the whole idea of POCSO was to be preventive. But the criticism is it has ended up being more punitive. Now, in 2019, it was amended to include death penalty for aggravated penetrative CSA. So what are your views? Does it require any change? What is ideal?
I would say it's very unfortunate that we think that if the punitive measure is very stringent, that is going to create a deterrence and that is going to bring down the rate of crime. It really doesn't happen that way. I would add to the amendment of 2019 in Maharashtra, now we also have the Shakti Act that talks about death penalty for rape and CSA cases that are penetrative in nature. It is not the death penalty that would really bring down the crime rate, but it's a certainty of the case being heard fairly and the perpetrators being punished within a fixed period of time, I would say, instead of the case going on for years and years and years, especially with children, because you cannot depend on their memory for too long. And that is why the law also has a stipulated period within which the case has to be over. And unfortunately, that is not followed. If you look at it world over, there are 108 countries who have completely abolished death penalty from their laws, and there are 144 countries who are not practicing death penalty at all. I think it's more of an emotional issue when it comes to sexual offenses and the media trial that happens around it, that we think that the death penalty is going to bring down the crime rate. Even when Shakti Bill came, and I was part of making the presentation to the committee that was bringing the Shakti Bill, where we said that you cannot equate a sexual offense to murder. The moment you equate sexual offense to murder, what is going to happen is that person may not be alive, because to commit a sexual offense and to commit a crime of murder, if the punishment is going to be death penalty, you kill that person and there is no evidence left for the court to really do justice in that case. And so death penalty, according to me, is not the answer to bring down crime rate. There are preventive measures that we definitely need to take to bring down crime rate. And unfortunately, because POCSO is a criminal law, we start talking of it only when the offense happens and not before it. So I think that's a very misguided notion that death penalty is going to work as a deterrence. It has not worked as a deterrence for so many years, even for cases of murders. So why will it work for cases of sexual offense? It will only lead to more murders, is what I think.
Now, since POCSO Act 2012 has been implemented, we as a psychiatrist are facing another challenge of mandatory reporting. So, we asked Dr. Bhushan Shukla regarding his experience and about the mandatory reporting as a psychiatric, and if there are any guidelines for it. Can we have the audio recording?
Answering the question about what is the most appropriate way to handle mandatory reporting clause of POCSO, I have tried this in personal capacity and with the help of some institutions like the Law College workshop, that government should become aware of the difficulties in mandatory reporting, because on the ground realization is that when you tell the family that child will be reported to the police, this incidents will be reported to the police, and they will have to talk to police and they can't walk out of it, the child and the family simply disappear. It has been a consistent pattern since introduction of POCSO that we have been able to give less and less help to more and more number of children. This is a big problem, and this is where mandatory reporting really hurts. But all our pleas to give us some time frame to get the child ready have completely gone on deaf ear of the government, and we haven't received any support on that front at all. So the real difficulty here is how do we go ahead with it? Many times I have encouraged the schools and the families to go and talk to the police directly when the child is not in immediate danger of being abused. So abuse has happened few days ago. Now the child is in safe place. There is no imminent danger. So we still have some time to talk to the family, get the child ready, and then the reporting can happen. If the child is in active danger, then obviously family needs to get involved, and sometimes I have picked up the phone and talked to the police myself. In all of this, there is a very high chance, more than half the cases, where psychiatrist ends up losing the rapport with the patient and the family. This is really unfortunate, but given the way government continuously views doctors as potential criminals or even, part of the crime.